Today, I want to talk about reasonable doubt. I'm going to go into the definition of reasonable doubt and also how it is used in the criminal court system. Hello, everybody. Welcome to Joe the Lawyer. I'm your host, Joe Pometto, a practicing criminal injury and family attorney in Pittsburgh, PA. If you like my content, please like, subscribe, comment, and share. It is a free way to support the show. Here on this channel, we cover legal life, legal topics, and legal news. And before we begin, everybody, raise your cup, your glass in the air, a short ritual that we do. It's called the same time sip. Sip with me because it tastes better when we sip together. Cheers. All right, some delicious coffee. So most people, whether or not they work in the legal system like judges or attorneys, have a vague understanding of what reasonable doubt is. Reasonable doubt is the burden of proof that a prosecutor has to carry in order to find someone guilty in the criminal courts. Many people get their understanding of reasonable doubt from movies like A Time to Kill or television shows such as Better Call Saul, Suits, Law and Order, perhaps the biggest one because it deals with the criminal justice system. Or we could even go back further to some of the classic TV shows like Perry Mason and Matlock. But does everyone have a good definition of what reasonable doubt is? Well, guess what I'm going to tell you? I don't know if there is a good definition, but let's take a look at some of the definitions that are out there. So this is from Cornell Law School. This is a definition that they have on one of their websites, which is actually really good for legal information. Beyond a reasonable doubt is the legal burden of proof required to affirm a conviction in a criminal case. In a criminal case, the prosecution bears the burden of proving the defendant is guilty beyond all reasonable doubt. This means the prosecution must convince the jury or a judge, this also applies if you have what's called a bench trial or a judge trial, that there is no other reasonable explanation that can come from the evidence presented at trial. In other words, the jury must be virtually certain, I like that as a defense attorney, of the defendant's guilt in order to render a guilty verdict. This standard of proof is much higher than the civil standard called preponderance of the evidence, which only requires a certainty greater than 50%. Now, I think that is actually a really good definition. Let's take a look because I practice in Pennsylvania. What does Pennsylvania call a reasonable doubt? What is their definition? And you're going to see how, we have the Cornell Law School definition. Now I'm going to give you the Pennsylvania definition. What if I told you that of the 50 states and then you have federal criminal courts, all of them have a slightly different play on what reasonable doubt means? Here's what Pennsylvania calls it. A reasonable doubt is a doubt that would cause a reasonably careful and sensible person to hesitate before acting upon a matter of importance in his or her own affairs. A reasonable doubt must fairly arise out of the evidence that was presented or out of the lack of evidence presented with respect to some element of the crime. A reasonable doubt must be a real doubt. It may not be an imagined one, nor may it be a doubt manufactured to avoid carrying out an unpleasant duty. I actually don't like the Pennsylvania definition at all. I think that it is slanted towards the prosecution because there is language in there that says it may not be a doubt manufactured to avoid carrying out an unpleasant duty. What does that even mean? And I think that line there can be used for a juror to get over any doubt that they have in their mind in order to convict, who knows, based on some sort of internal bias that they have. The one thing I like about the Pennsylvania definition is that it tells the court, it tells the jurors or the judge, remember, a judge can be making a decision, to rely on the evidence, right? They can only look at the evidence presented in the case in order to make their decision. Now, what a lot of lawyers like to do is use an analogy to describe reasonable doubt. And I'm going to give you one which I sort of like here. Assume that you were to learn that there was a complete videotape of the incident you are considering. If you think you'd really like to see that videotape before deciding to convict my client, I suggest that you have a reasonable doubt. If you would say, don't bother, no need for us to see the videotape, then I suggest it's only then that you can find guilt beyond a reasonable doubt. Now, that's a nice analogy. However, what if there actually is video of the crime, which sometimes happens in criminal cases? Then you got to throw that one out the window. Some attorneys talk about a puzzle. This is something the Commonwealth will actually do, but a defense attorney would say reasonable doubt is like a puzzle. And when you put the puzzle together, if there are still significant pieces missing, then that is a reasonable doubt. But what a prosecuting attorney will say, they will say, look at the evidence presented today. Each piece is a piece of a puzzle. And as you can see, I have built the entire puzzle. Or they could say, well, there's still a couple of pieces missing. But that does not mean that you can't find the defendant guilty. You still can. And then they can jump back to that Pennsylvania definition because it gives jurors a way out, in my opinion, in order to find someone guilty. So after all of these definitions, you may still be confused about reasonable doubt is, what reasonable doubt is. Let's go back. This is a way that I like to describe it to juries. I like to go back to that Cornell definition and explain to juries what a burden of proof is. Again, the burden of proof has to be met by the evidence that is presented at trial. And at a civil trial, the preponderance of the evidence, that burden, it means that a civil jury, in order to find in favor of the plaintiff, the person bringing the action, it only has to be more likely than not that the plaintiff's story is true. That's like that's 51% to 49%. 51%. So you can still have significant doubt and still find in favor of the plaintiff and walk out of there as a juror saying, I did my job, even though you really don't know for sure what happened, right? What's 51%? A little greater than a coin flip. Then there's another burden called clear and convincing evidence, which is higher than a preponderance of the evidence. Maybe 60, 65%, somewhere in that area, that you have to be sure before finding in favor of the moving party, the party bringing the case. Then reasonable doubt, and we can't say this to a jury, is like 80% certainty. 80% certainty. So that's a pretty high degree of certainty. As a criminal defense attorney, I don't have to ponder too much about the definition. I start in my mind, I think the jury needs to come to that 80% burden. So how do I look at reasonable doubt? Just like a plumber may have a wrench as a tool in their toolkit, right? A police officer and Batman, they have their utility belts, right? Where they're going to have tasers, they're going to have handcuffs, they're going to have a firearm. Each of those are different tools in their toolkit. I view reasonable doubt as a tool in my toolkit. And the ambiguity that comes with the definition favors me because I will take the definition of reasonable doubt and I will tailor it to each individual case. Let me give you a few examples of reasonable doubt that I may use. Okay, I believe that there is a reasonable doubt. I can argue this to a jury if there's a reasonable alternative story. So the Commonwealth is going to put 4 or 5 witnesses on the stand. They're going to tell a story. If I can produce a couple of witnesses that also tell a different story, then I can put these two stories up against each other. And even if the Commonwealth story comes off a little bit better, my story may still be true. And as long as it doesn't conflict, okay, if there's a direct conflicting of evidence, that's something else that we have to deal with. But when you have two plausible stories, two plausible version of events, I would argue to a jury that is reasonable doubt, and they must find in favor of the defense. Another argument that I use with reasonable doubt is a lack of evidence. So oftentimes, the police and prosecution will bring cases against against defendants where they don't have as much evidence as they would like. And I will point that out throughout the trial. You don't have fingerprints. You don't have DNA evidence. There is no videotape of what happened, okay? All that stuff can add up. And I will say, listen, members of the jury, that is a reasonable doubt. There's this evidence that was not presented that should have been or should have been gathered that could remove that reasonable doubt. The Commonwealth has not done that. The prosecution, I live in Pennsylvania, so the ones bringing the case are Commonwealth. Pennsylvania is a Commonwealth state. There's a couple others, Massachusetts, Virginia. So that is another way that I paint reasonable doubt. I use it as a tool and tailor it to the case. Finally, let's talk about credibility. And this goes back to what I was saying with the reasonable story. Each side may present a suite of witnesses, right? Sometimes the prosecution's witnesses are not credible for a whole variety of reasons. They may have a built-in bias towards the person that they are trying to attack, or they may themselves be accused of crimes, and they may only be testifying to avoid criminal charges of their own or a severe or harsh criminal penalty. So that also can be argued is a reasonable doubt. So I hope you learned something from this video. You can see the definition of reasonable doubt. I would go back to that first one. I actually think that's the best for explaining it to the average person and having an understanding of it. The courts, the Pennsylvania version, the analogy that I presented to you, my little spiel I don't like Pennsylvania's. Obviously, I'm coming from a biased point of view. Go back to that first one. I'll put it down there. Read that one. That, I think, is the best definition of reasonable doubt. But I also hope you've understood how it can be used by attorneys as a tool in the toolkit. And the prosecution, remember, they have all their own little analogies and twists that they put on reasonable doubt. So it's often fun to see the sparring versions that come up in a trial. Ultimately, the evidence presented is going to carry the day, but it's the job of the prosecuting and the defense attorney to paint their case in the most favorable light possible. So thank you for tuning in. I'm Joe Pometto, Joe the Lawyer. If you like my content, please like, subscribe, comment, and share. I hope you learned something here. We cover legal topics, legal education, legal news, legal life. Thank you, everybody, and have a great day.